Good morning, everyone. First of all, I would like to thank Dr. Amber Dar for inviting me to talk about a topic which is very dear to me, comparative contract law. Unfortunately, due to unforeseen circumstances which led to cancellation of classes, we decided to pre-record this video so that you can watch it at your convenience. I also want to inform you that I plan to put a link to the PowerPoint and was supposed to accompany the original lecture below so that you can follow the video hopefully more easily. Now, why is comparative contract law dear to me? I was fortunate to earn my law degrees in France, where comparative law, including comparative contract law, are very well developed subjects with a long tradition. And I was encouraged to take quite a number of them. In fact, one of my LLMs is in international economic law and globalization, and I was encouraged to take a number of comparative contract law classes as part of this program. And I find this quite an important approach because quite often those who do not have an expertise in comparative law, including comparative contract law, perceive it as a very theoretical discipline, and in fact, it has some important practical applications as well, as we will see. Now, after I finished my law degrees, I practiced law for a little bit, and then I defended my PhD in comparative contract law. And to this day, comparative contract law is one of my main research interests. So. In that light, I wanted to just warn you that there are mainstream methodologies, there are mainstream comparative lawyers, and there are comparative lawyers who engage in less conventional work, and I do both. So from time to time, I engage in classic comparisons, such as comparisons between English and French contract law, but from time to time, I try to do more unusual things, such as compare the common law to East European jurisdictions in an attempt to promote comparative dialogue between West Europe and East Europe. Now, what we'll do today, if you look at slide 2, I think it's important to give you a brief historic overview of the latest developments or the more recent modern developments in comparative contract law, so that you realize why it is an important discipline. And then I'll focus on three main questions. Why should we compare? So, what's the purpose? What are the goals and aims of comparative contract law as a discipline? What could be compared? And you would see that depending on whether you talk to a more conservative comparative contract lawyer or a more modern, I would dare say, comparative contract lawyer, you would see that they have very different views on what could be compared and what should be compared, which is a fascinating debate. And last but not least, I think it's important to talk about methodology and the conflicting views of regarding what methods are reliable within this discipline. So, moving on to the historic overview, you may hear that the birth of modern comparative law, including comparative contract law, is associated with the first International Congress of Comparative Law, which took place in Paris in the year 1900. Where they had a very ambitious program. They were talking about the common law for all civilized mankind. So, from the perspective of time, clearly this was not realistic, but this was a very important event which gathered experts in comparative law at the time. Now, there is debate when comparative law originated. You would see various theories, whether it existed even in Roman times, etc. But what is believed to know, what I believe is important to know, is that comparative law, including comparative contract law, started to solidify as a discipline in the 19th century. So this is when the first societies for comparative law were established. The first one, I believe, was in France, and then subsequently one was established in England. But also, scholars started teaching comparative law in at universities. And I was fascinated to discover a PhD defended at the end of the 19th century that examined more than 20 jurisdictions. So they engaged in serious work. Of course, it was this event that provided a new impetus for the discipline, including a new impetus for comparative contract law, because as you see, initially the ambition was to harmonize all areas of law. But if you examine the historical development of the discipline, you would see that the first outputs, the first products of this comparative dialogue were actually in the area of obligations. And just as a terminological clarification, obligations covers contract and tort, and unjust enrichment in the jurisdictions that, of course, recognize it as a separate sub branch of the law of obligations. And I wanted to give you some examples of concrete legislative initiatives that materialized. One of the examples I've put on in this presentation is a Franco-Italian draft code of obligations of 1927. France and Italy planned to have a common law of obligations. Unfortunately, they couldn't enact it because of political factors. Mussolini rose to power. He had his own view of how Italian law had to develop, and so this project is just there, and it has historic value. Now, another example I wanted to give of a concrete output that materialized as a result of comparative work in the area of contract law is the Polish Code of Obligations of 1933. It's considered a very sophisticated example of a compilation because they borrow principles uh, from the laws of France and Germany. Um, the Uniform Commercial Code in the US of 1952 is also an example of a piece of legislation that was developed through comparative work because the father of this called Karl Llewellyn, I hope I don't butcher his name, but he was very much interested in German law. He was a fluent German speaker. He taught law in Germany, so it's very interesting that this Uniform Commercial Code, of course, synthesizes principles of the common law, but introduces elements that are common in German law, such as the notion of good faith, commercial impracticability, etc. Now, on an international scale, I believe that the most impressive achievement we have, um, which is a result of rigorous comparative dialogue that lasted for decades, is the Vienna Convention on the International Sale of Goods, which was signed in 1980. Its genesis is in the 60s, I believe, but it's an example of a sophisticated legal instrument that is enforced today in countries, in nearly 100 countries which have ratified it. The UK hasn't ratified this, so beware. But still, on a global scale, this is a very, very important binding instrument that's the product of comparative work and comparative dialogue in the area of contract law. Now, other examples of initiatives which are important are concrete outputs of model rules. Model rules, they're not binding. You could take them as guidelines. So they serve a dual purpose. They aim at harmonizing by inspiring jurisdictions to borrow principles from them, or alternatively, parties can choose these model rules, these principles as applicable law to their contract if they choose alternative dispute resolution as a mechanism for well as a mechanism for resolving disputes. I've given you two examples which I believe are important. There are many others, but I didn't want to overburden you with information. These are just, I guess, examples you can use for your exam, for instance. But the UNIDROIT principles, or the principles of European contract law, etc. Of course, we shouldn't forget the efforts of scholars, both individual efforts and more organized efforts. They're important academics who have contributed to the study and development of comparative contract law through monographs, articles, textbooks. And since I mentioned the 1933 Polish Code of Obligations, I was fascinated to discover a monograph by a Bulgarian scholar who engaged in a comparative analysis. He tried to show the differences between this Polish code and Swiss, German, and French law. So he did very sophisticated comparative work, and the goal, of course, was to advance the study of comparative contract, but also to inspire East European legislators. So this was an interesting example of an important contribution that also has historic value. And as I mentioned earlier, since the 19th century, we started seeing the establishment of comparative law societies and associations, and I've given you several examples, including the example of the society, the Association Henri Capitain. It's a French association that initially started to promote French law. It wanted to promote dialogue between jurisdictions that sought inspiration in French law, but very quickly it became a forum for comparative dialogue, and they engaged in dialogue with other jurisdictions that were not related to France. Now, the most glorious days, if I dare say, of comparative contract law were maybe, or maybe the 1980s and 1990s. This is when people started getting a bit ambitious again. This is when the European Union embraced harmonization of private law as a project. This is when we saw, the development of the first European consumer directives, and I'm sure by now you've studied the Unfair Terms Directive. That is traditionally one of the hardest questions on exams involving English contract law. But initially, the European Union started with development and implementation of directives, but then they became even more ambitious, and at one point in time, they wanted to develop European civil code, and this, of course, was related to the constitutional project that they had at the time. But this project failed, and so the project for a civil code was not implemented. But we still have a draft, and that's why it has a name that puzzles people. The draft common frame of reference. It's a sophisticated name for a document that is actually the draft for a European civil code. It has remained there as a source of inspiration, which legislators in the European Union, and not only can use when they modernize their laws of their private laws. It has a relatively large scope. Now, without further ado, we're moving forward to the most interesting aspect, to the more interesting aspects of this talk, the questions. And now we'll be talking about mainstream narratives and less conventional narratives that show that mainstream narratives are sometimes related to myths and legends. So there are quite a few stereotypes out there which haunt comparative contract law. Now, the first question I would like us to examine is, why should we compare? Why should we engage in comparative studies between the contractual laws of various jurisdictions out there? According to many comparative lawyers, we need to have a very practical purpose. We shouldn't be that theoretical, we should be more practical. So the first goal is harmonization. And what do we mean by harmonization? We mean the identification of either common or better principles, which can serve as the basis of the development of common instruments. And in this way, We promote international trade, we promote the exchange of goods, we promote globalization because it has been argued, and even there is empirical research which shows that the various differences between contract laws out there prevent international trade, or rather, they serve as barriers to trade. So, if you have common instruments, ideally trade would be facilitated, and this is the philosophy behind instruments such as the Vienna Convention. On the international sale of goods, which I already mentioned. Now, the development of such instruments also has a symbolic role. It plays a role in nation building and political integration. And in a sense, this idea also underlay the harmonization project in the European Union. That's why they wanted to draft common frame of reference, or something like a civil code that would make us feel more as if we were headed to the United States of Europe. But now we know that this goal is far fetched, and maybe it wasn't even realistic at the time it was conceived. Now, pay attention that these harmonizing instruments can either be binding, such as the Vienna Convention on the sale of goods, or they could be non-binding, so they could just serve as inspiration. For instance, the principles of European contract law, etc. A second important aspect here, which is also related to the practical purpose of comparative contract, is the idea that you can improve the contract law of your jurisdiction if you study the contract laws of other jurisdictions. Maybe they're better, or maybe by just comparing, you can identify weaknesses in your own legal system. And since we're talking about contract law, maybe some weaknesses in in the contract law of your jurisdiction. Now, this approach, in a sense, also promotes globalization because jurisdictions tend to borrow from the same places. Very often, we know that the key actors that promote innovation in the area of private law are traditionally Germany and France, and so many jurisdictions look up to them, and so they end up creating compilations. So, in a sense, you could find the same principles in the contract laws of continental jurisdictions. Um, Considering that we've also developed model rules, and now everyone that wishes to reform their private law or their contract law takes a look at these rules, we still achieve this goal of harmonization in a soft manner, and we promote globalization. I've given you examples from different time periods. And I'm just fascinated by this Polish Code of Obligations from 1933, so I often include it. But as I said, they borrowed from Germany and France, and they created a compilation, which was a very important intellectual achievement at the time. Then, after the fall of communism, many East European jurisdictions sought inspiration in West European countries, and they sought inspiration amongst each other as well. I'm originally from Bulgaria. I have an interest in Bulgarian law, in Bulgarian contract law in particular, and so I know that when carrying out reforms after the fall of communism, Bulgaria looked up to France, Germany, Hungary, and Poland, for instance. So you have comparative dialogue there. Now, a more recent example is the recent reform of the French law of obligations in 2016, and legislators specified that they sought inspiration in model rules such as the principles of European contract law, etc. So as we see, comparative contract could have very practical goals and can help enhance trade and globalization as such. Now, of course, there is a counter narrative too. So moving on to the next slide. The alternative narrative is that comparative contract law should have idealistic goals such as enhancing knowledge of legal cultures. Of course, the idea that law is a cultural product is not new. It is often attributed to the spirit of the laws by Montesquieu, a very important study, which is often quoted in other areas, including areas of law, including political science, because Montesquieu had important ideas for our democracy, such as the separation of powers, etc. But he's often credited with contributing to comparative law as such. And I have included the quotation which could be helpful. The political and civil laws of each nation should be adapted in such a manner to the people for whom they're framed that it should be a great chance if those of one nation suit another. So this is the harbinger that law, including contract law, is a cultural product because it emanates, it illustrates the political beliefs of the drafters at the time, the values of judges, the values of scholars, etc. So it can only operate within the nation, within the country for which it was created. And indeed, contract law is part of the law of obligations, which in turn are an important part of private law. And private law is often considered a symbol of national identity. It could be a source of pride. The development of new principles of private law often symbolize historic change. And I've given you an example of such a product that is considered to have a symbolic value. The French Civil Code of 1804, the first civil code that has been enacted. That is an important intellectual achievement, but it's such an important symbol of French identity that French jurists are very very much afraid to criticize it, to reform it. In fact, I mentioned earlier that there was a reform of the French law of obligations. When I was a student in France, my professor, who's a leading authority in the area of French obligations, told us that he believed this reform would never be completed in his lifetime. But he was wrong. They did manage to reform it. But there is a stigma associated with touching such cultural artifacts. I dare say. Now, from this perspective, of course, harmonization is a myth because we believe that from this perspective, legal cultures persist, and so in a way. Arguments in favor of this claim have been put forward by examining case law by the European Court of Justice. It was renamed as the Court of Justice of the European Union, but this court is supposed to have a key role in promoting the uniform interpretation of EU law, including directives pertaining to consumer law, which are relevant from the perspective of comparative contract law. Now, what scholars have discovered is that, in fact, this harmonization project that includes directives on consumer law lead to new divergences. And I'm sure that in your class on English contract law, you've discussed, for instance, peculiar English cases pertaining to the unfair terms directive that English judges tend to ignore uh, case law by the Court of Justice of the European Union because the values of the English legal culture, such as commercial sensibility, freedom of contract, prevail. But this is not just the case for England that clearly falls under the scope of jurisdictions that have been heavily influenced by individualism and in such a framework, of course, freedom of contract is the primary value. You have other jurisdictions that have been influenced by ideas of social justice. There are other jurisdictions in the European Union that have faced communism and as a direct result, fairness and good faith somewhat trump freedom of contract. This is often the case. So uh, it's important to bear this in mind, that even case law uh, by the European Court of Justice, which is binding, hasn't helped much in harmonizing outcomes in the European Union, which shows how powerful and persisting legal cultures could be. Now, even of course, even if we assume that harmonization is impossible, and comparative contract law in this way has a more important role in promoting dialogue rather than harmonizing and promoting globalization as we know it. There's still some benefit for the globalization project because, in a sense, the study of comparative law eliminates uncertainty. Think about it. If you take a class in comparative contract law and you're introduced to other legal cultures such as French law or German law or Spanish law, then if subsequently you advise an English company that negotiates with a foreign company, for instance, a French company, you may be better placed to carry out more efficient negotiations, because even if you choose English law is applicable to your contract, your French counterparty may have some concerns, and you may relate to them better if you understand where they're coming from and what principles are key for their contract law. So in this way, we still promote globalization and cultural dialogue. Cultural dialogue is important in that regard. Now, moving to the next question, which I find important, because there are a lot of stereotypes and I would say borderline discrimination even. Which contract laws could be compared? Now, if you talk to more conservative uh, comparative scholars, they may tell you that you should always be guided by the theory of legal families. And I'm sure you've mentioned this theory when you've discussed other areas of comparative law, but it's a theory that informs research in comparative contract law as well. So this theory divides legal systems into families. So the main ones are Romanistic, the Romanistic, the Germanic, and the common law family. And according to this theory, legal systems should be grouped based on similarity and based on where they sought inspiration from. So the Romanistic system has French law as the parent system, and then everyone who borrowed from France is put in this family. Then, respectively, England is considered the mother or the parent of the common law, and then jurisdictions that inherited or borrowed from the common law would be put in this family. Now, I don't want to enter into too much detail because this theory is not homogeneous. It has been revised. There are various scholars who have contributed to its development, and it may serve a good purpose, or rather, back in the day, it served a good purpose. According to this theory, however, you should compare the parent systems. So they encourage you to compare French law to English law or French law to German law. Or alternatively, you could compare systems within the same family, such as, well, English contract to Australian contract, or English contract to Canadian contract, etc. In reality, however, this theory has quite a few deficiencies. The most obvious one is that jurisdictions borrow from different places. So, as I said, for instance, there are some German influences in the Uniform Commercial Code, but based on the original version of this theory, you had to compare uh, U.S. law to English law, not to German law. So in this way, you have artificial constraints that do not reflect reality, that do not reflect the process of globalization, because of which jurisdictions have opened up, and they're looking for inspiration in diverse places. Now, what I've also discovered through my work is that this theory is based on political stereotypes to a large extent. For instance, during communism, all East European jurisdictions were put in the same family. And I believe that this is just a case of political labeling because these statements were often not grounded on substantive research into these contract laws or these systems, but rather this labeling was based on the assumption that they had the same political system. And then after, of course, the fall of communism, scholars who subscribe to this theory of legal families had huge difficulties of classifying East European systems. So you'd often see an East European label out there. What I've discovered through my research, this was part of my PhD research, was that Bulgaria during communism borrowed its law of obligations from Italy, and Italy is part of the Romanistic family back in the day. So I find this. I think that this illustrates how inefficient and even biased this theory is because Bulgaria was put in the East European family and Italy belonged to a different family. So from this perspective, they shouldn't even be compared. Wow, I actually believe that comparing them is fascinating because it shows you how the same principles function uh, in different political environments, and this could be quite exciting. So, I would advise you to follow the subject and the context rather than the labels. This is especially valid if you do research, comparative research in contract law between EU member states. So you may compare how England applies, of course, the Unfair Terms Directive to how Portugal applies this directive. You don't have to pass through France or Germany. But even if you deal with areas of contract that haven't been harmonized, there may be something in the context or the subject itself that signals that a given comparison is appropriate. For instance, the main focus of my PhD was in commercial impossibility, and I discovered that different jurisdictions respond to commercial impossibility in very, very different ways. And there was a spectrum, a range of responses. And I noted that England was on one end and Bulgaria was on the other. And that's why I chose to compare these jurisdictions. So the angle could signal that a given comparison is appropriate, even though it doesn't subscribe to the conventional theory of legal families. Unfortunately, this criticism hasn't been embraced by those who teach comparative contract law at university level. I would say that virtually all classes in comparative contract law I have taken were informed by this theory. So we focused on the contract laws of England, France, and Germany, and I believe this is unfortunate because there are other jurisdictions out there with rich legal cultures that deserve to be studied, and especially if our goal is to promote cultural dialogue and international trade. We are part of a global community, and such discrimination based on political stereotypes is not advisable. Now, the last question I wanted to cover, and we don't have much time for this, but still it's important. This is a key question for comparative law, including a key question for comparative contract lawyers. How should we compare? We've settled on a given angle, or we've discovered something interesting. What should we do? And here, the mainstream methods, and maybe by now you've heard of it, is the functional method. This functional method is considered the dominant method of comparative law, including the dominant method of comparative contract law. And it seeks to answer whether principles and rules of contract play the same role in different jurisdictions. I believe that this principle is hugely important because it helps scholars identify and combat basic mistakes. You would see that there are many scholars who are not comparativists by training, but who use comparisons in their work, and this functional method could help you find the weakness in their work. You would see that very often some scholars who are not comparativists would say that, well, a certain principle exists, such as good faith. Let's say negotiations in good faith. This principle exists in Hungarian law and French law, and therefore there are important similarities between these jurisdictions. And if you rely on the functional method, you would have to take a look into how courts apply this principle. And ideally, you should find cases pertaining to similar circumstances. You'd also look into doctrine to see if this principle is defined in similar ways, and only then you can conclude that there are important similarities between Hungary and France, for instance. Um, it may be the case, this often happens, that scholars who are not experts in comparative law and comparative contract law would say, well, this jurisdiction doesn't have this doctrine, therefore there's a huge divide between France and England, because English contract law doesn't recognize good faith as a general principle of its contract law. Now, that is somewhat misleading, and once again, the functional method is here to help, because it may be the case that there are other doctrines that help English judges achieve the same result. So they may reach the same result with the doctrine of mistake, for instance, or the doctrine of misrepresentation. So once again, it's important to find case law pertaining to similar facts. And if the result is the same, then the fact that it was achieved by application of different doctrines doesn't necessarily signify that there is a huge divide between these jurisdictions. Now, something you should bear in mind, that the functional method, of course, has weaknesses. I think it it's important, but it may mislead you, because the fact that certain principles are applied in a certain way today doesn't mean that they will be applied in this way in the future too. So I would say that ideally it's not just important to compare case law pertaining to similar facts, but also cases that were decided, handed down in a similar time period, because jurisdictions evolve, people evolve. You have new schools of thought that develop, and so it may turn out that a new school of judges has been heavily influenced by a new book, or they took the same class with the same famous professor, and all of a sudden they start applying a given principle differently. And there are examples of such developments in France, for instance. So I find this fascinating. Now, that's the mainstream method, the functional method. An alternative methodology would include um, examining context. So you have identified some differences and similarities between legal systems, but they wouldn't be that important, or your research and your study would not be that fascinating unless you examine context. So here. There are various theories. I didn't want to enter into too much detail, but the whole idea is that there are various factors that contribute to enhancing differences between legal systems. History is important, political ideas are important, political processes are important. As I said earlier, because of globalization, because of political changes, East European systems have started looking up to West European systems to modernize their laws. So in this way, we can explain some similarities that exist. Of course, the background of judges, the background of scholars, the background of drafters can also play a huge role. And to give you an example, which you can relate to, for instance, I'm sure that you've all heard of Lord Denning by now. So I think that, and you know that he was one of a kind, and he was very different. He was very different from other judges. So the personality of the judge, his personal values, his education, etc., could also be relevant, even when it comes to contract law. Of course, the specifics of the economy, geography, climate may explain why certain principles of contract exist in certain areas or certain regions or certain countries, and not in others. So this is hugely important to bear in mind. So that's all from me. I hope you enjoyed this talk, and I will leave the comments below this video open so that you can ask me questions in case something was not clear. Thank you very much for your attention, and best of luck for your exams.